guys, welcome to Hip Hughes History. We're going to take care of the Fifth Amendment for you in about the next 10 minutes. One of the most important amendments of the Bill of Rights. In fact, if I had to rank it, I'd rank it in the top 10. As we continue for the Constitution for Dummies series, I'm not calling you a dummy because I love you. And I love the learning, so giddy up, here it comes. Alright, you guys know how this works. If we're going to talk about the works, if we're going to break it down, you need to know the words. So, Maestro, music please.
No person shall be held to answer for a capital or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation.
So we can basically break this up, guys, into 5 parts. We're going to take a look at what a grand jury is and what that means. Then we'll take a look at the idea of double jeopardy, really important in there. One of the biggest idea, of course, is your right to remain silent. We'll discuss that. And then we're going to take a look at the due process clause, which muy importante. And then we're going to take your land for just compensation. So let's break it up. Let's do it. 5 pieces. You know you can handle it. So, grand jury. What is a grand jury? It's really simple. And first you need to know it's only for federal government. There are state grand juries, but it's up to the state. The Supreme Court has never selectively incorporated this part of the Fifth Amendment, meaning they haven't used the 14th Amendment's no state shall deny its due process clause to apply grand juries to the states. So only to the federal government, and not in times of military trials and things like that. You heard that in the amendment. This only applies to federal crimes for infamous crimes, meaning felonies. That's how the Supreme Court has defined this. So if you commit a felony, and it's a federal crime, you get a grand jury. So what the hey is a grand jury? A grand jury comes before you're indicted, before you're arrested. In a sense, it's supposed to protect you against overzealous prosecutors. If you're my neighbor, and let's say you're, 18, 19, you party all the time, you're playing your kid music, and you're doing the tweaking or the twerking or whatever that is, and I'm a cranky old man, I could really mess with you if I didn't have to go to a grand jury. I could just arrest you for murder. Yeah, that would screw you, right? You'd have to get a lawyer, your family and friends would be looking at you cross-eyed, your girlfriend would leave you, or your boyfriend would leave you, no one would love you. You'd be living in a van down by the side of the river. It's a Chris Farley joke. But needless to say, you do need to go to a grand jury to avoid that. And the grand jury is basically like a regular jury. They listen to the prosecutor and the evidence. Now, you don't get to bring your defense lawyer in there, and certain rules apply that are much more broad. There's no exclusionary rule in a grand jury. So if you found evidence illegally, it's all good, baby. But basically, it's just to make sure that if I'm going to go forward, that there's some type of reasonable suspicion, there's some type of evidence, there's enough evidence for a trial. I'm not just getting you because I don't like the twerking. Is it the tweaking or the twerking? So that's what a grand jury is. Now, most states don't do grand juries. Most states have what's called preliminary hearings. You've probably seen this on Law and Order, where you present it to a judge. So a little bit different for the state. Giddy up, here we go. I think I'm going to do Jeopardy! Double Jeopardy! Alright, you've seen the movie Double Jeopardy, then you could just fast forward this part. But Double Jeopardy basically means that I get one swing at the bat with you in terms of a trial. If I arrest you for murder, and then you are convicted or acquitted, that's it. I've had my shot. I either got you or I didn't get you. So in its very most basic form, it's just to protect you against multiple prosecutions. Now, if it's a mistrial, it depends on who calls the mistrial. But generally, mistrials can generally lead to new trials unless it's prosecutorial, misconduct, like the prosecutor is cheating or lying and there's a mistrial, then the prosecutor doesn't get another chance. There's also some pretty strict rules in terms of that I can't charge you. Let's say you murder 3 people in a crime, right? Why don't I just charge you for murder once? If you get off, I'll just charge you for murder again for the second person. Then if you get off again, then I'll charge you for the third murder. 3 different murders, 3 different trials. No. I think it's called the Blockberger rule after a famous Supreme Court case that says if the crimes are tied, you have to try them at once. You can't have multiple opportunities to try those crimes. Now, if I rob a bank, and then a few days later I decide that I'm going to, steal a meth van, then those are 2 different crimes. They can have 2 different trials. You shouldn't rob banks and you shouldn't rob meth vans, I'm just saying. All right, let's take a look at the next part, which is one of my most favorites. All right, you have the right to remain silent. And of course, this is probably the most famous part of the Fifth Amendment, talking about the right not to be a witness against yourself. And certainly this traces back, like much of the Bill of Rights, to the Magna Carta, and I think back to Oliver Cromwell, and the concept of not having, to be self-incriminatory against yourself, where that comes from. But the very basic concept is certainly at a trial, you do not have to take a stand. The government has something to prove. You do not have to help them. You don't have to be like, I'll help. You think I did it? Here, I'll go. What do you want? What do you want to know? No, you certainly don't have to do that. And technically, you don't have to answer any question the police gives you. I believe you do have to give your ID. Most states have laws. This was a recent Supreme Court case where you have to turn over your ID. But you don't have to answer questions. If you don't want to, you don't have to. And you certainly always can invoke that right and invoke your right to a lawyer and invoke the right not to consent to a search. If you know those 3 things, I invoke my right to remain silent. I'm invoking my right to an attorney. I do not consent to any searches. That's probably the 3 strongest sentences that you can give to protect yourself with the Fifth Amendment. And of course, the Fifth Amendment's been used in other circumstances. Most famously, it was used by the witnesses or the people that were being accused of being communist in the HUAC trials, the House on Un-American Activities trials, the McCarthy hearings in the early 50s. And they were labeled Fifth Amendment communists, because the country saw them invoking this liberty, this right to say to the government, I'm not going to help you, convict me or accuse me or give you evidence that I did something as evidence of guilt. So Miranda comes from Miranda, Arizona, where a defendant, Ernest Miranda was being accused of a pretty gruesome crime, and he was being questioned over and over and over, and he didn't know he had the right to remain silent. Really low IQ. Eventually he broke down. He confessed to the crime. And then that confession was used against him at trial. And what the court did in 1966 is they took that concept of self-incrimination and they said it's so important, it's so ingrained in our way of life that once you are detained, once the police detain you and you don't have the right to leave, they have to inform you of these rights. And of course, you've heard the Miranda warnings before. You have the right to remain silent. Anything you can say can be used against you in a court of law. You have the right to an attorney. If you can't afford one will be given to blah, 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 right? So the Fifth Amendment, really important, knowing your Fifth Amendment rights. Nor be deprived of life, liberty, or property without due process. There it is, guys, the Fifth Amendment's due process clause. And what that means is, in its most basic form, that we have procedures. That if we're going to arrest you, you're going to be informed of what you're getting arrested. There's going to be a trial with attorneys. There's going to be procedure. Everybody's going to get that procedure, and everyone's going to know what that procedure is. So when we arrest you, when we take away your life, we take away your liberty, right? That everybody knows the rules of the game. Now, we also kind of have the concept of not having, vagueness in law in there. So if I'm going to arrest you, it's got to be specific. You're getting arrested for felony class 149, right? You, ate the paint off your neighbor's house, whatever it is. But I can't be, you're getting arrested because you're really bad. You're a bad, bad man. That's kind of vague, right? I want to know specifically. Now, where it gets a little bit tricky is when the language is more in terms of substantive democracy, kind of like democracy that's unmentioned in the Constitution, but we all agree upon. So something like privacy. So for instance, if I'm going to pass a law that's going to, I don't know, ban what you do with consenting adults in a room, contraceptives or certain types of acts or whatever, that's taking away your liberty without due process. So people that argue that the Supreme Court is too powerful, that it's activist, would argue that the due process clause has been expanded and it's too flexible, where people that are interested in preserving individual liberty over what the majority of citizens want, like for instance to pass a law to tell you what to do in your bedroom, would argue that the justices are just putting into action the spirit of liberty in the Due Process Clause. So the Due Process Clause is repeated in the 14th Amendment. We're going to make sure after the Civil War that states also are guaranteeing its citizens due process of law and equal protection. We'll get into that a little bit later. All right, I want your land! I want your land! I'm going to take it. The taking clause. This doesn't sound good, doesn't it? Well, the taking clause is eminent domain. And what this basically means is that when it comes down to it, that the government and the federal government, and it has been applied to the state through selective incorporation, the governments have the right to take your land for public use. So in its most basic forms, with just compensation, and of course people are going to argue what just compensation is. If you buy a piece of land and you're, I don't know, building a casino on it or a carnival on it, and you know it's going to be worth a lot of money, they're not going to give you the money it's worth tomorrow. They're going to give you the money it's worth today. Now, where it gets a little bit shady is in recent years, the Supreme Court has argued that the government can take away your land for just compensation for commercial reasons. So if a developer is building some type of housing or something near the river downtown, they're revitalizing the neighborhood, the Supreme Court has ruled, and you write about this in the comments below, that if it's for the benefit of the community, it's creating jobs, tax revenue, that they have the right to your property. Not for public domain, but for a private domain that benefits the public domain. So what do you think about that? So there you go, guys. That's the Fifth Amendment chopped up. Chop, 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 chop. Hope you learned something. Make sure you click the button right there. I don't know, I'll put a button up later. You can click something. It's right there, isn't it right there? And that'll take you to the Constitution for Dummies series. If I step over, if you click right there, then you're going to be taken to subscribe to Hip Use History, because you certainly should be subscribing because it's the right thing to do. And check the description below. We have other EDU channels that you should be checking out. Lots of great information down there. And you know what I'm going to say, because I say it every time. Snap, where attention goes, energy flows. It's the rule of life. We'll see you next time, guys. Adios.